Well, Victoria is introducing a bill that will allow lawyers to charge their clients contingency fees. That is a percentage of their winnings. Now, contingency fees are commonly used in the American legal system, and it would see major Australian law firms who deal in class actions with major monetary wins benefit greatly. To date, contingency fees have been banned in Australia, hence the need to change the law to bring them in. But should we bring them in? There's a lot of experts who are fearful that this is a descent into a US-style litigious Australia that once we're headed down this track, we will not be able to undo. Mr Chris Merritt, Legal Affairs Editor at the Australian newspaper, was one of the first out on this issue, and he joins me now in Sydney. Chris, thank you very much for your time. Let's start at the beginning. Assume no legal knowledge out there. What is the contingency fee? And how is it different than perhaps what we see advertised, no win, no fee?
It's a commission. If you win $100 in a class action, a lawyer could charge you a commission ranging up to who knows what, 20%, 25%, 30%, who knows. It's very different to the way all other lawyers charge. They charge an hourly rate. They might, if you win, you might be able to increase that by a factor of, say, 25%, but not, that's 25% of their normal fee. It's not 25% of what the client earns. The problem with this is it's a massive conflict of interest. Instead of the lawyer working for the client, the lawyer and the client have opposed interests. The lawyer will take some of what the client earns. That's not the big problem, though. The big problem is that it will supercharge the class action industry, which is doing very nicely and has done very nicely here for class action lawyers for quite some time. And if you're going to pick any moment where this would be a bad idea, now is it. The economy is teetering. The federal government is doing everything it possibly can to try and get things moving again. And Victoria is thinking about increasing the litigation risk confronting all companies, all businesses, not just those in Victoria. You could have class action law firms from Queensland initiating claims on a national basis in Victoria.
Now, that's the point I wanted to pick up, because you were talking there about class actions, and of course they would want there be an incentive, a draw card, to file in Victoria, that even if it was predominantly, let's say, a Queensland legal case, you'd be looking for a potential plaintiff in Victoria to file in Victoria to avail yourself of contingency fees. Isn't that the risk? And then why, if it is all of these things that you've said, and I agree with you, why then, or what's the argument being used by the Victorian state government to bring it in?
The argument being used by the government is the argument being used by the very well-connected class action law firms of Victoria, two of the big ones, Slater and Gordon and Morris Blackburn. And that is, allow us to do this, it will increase access to justice, and by that they mean the amount of litigation. Now, the problem with this entire debate is that it's been run by lawyers all the way through. They've very carefully worked out ways to make class actions and litigation smooth and efficient and wonderful, which is terrific, but it fails to take account of the big picture, the broader economic picture. As long ago as 2018, the Australian Law Reform Commission, which favoured contingency fees, said, look, you've got to look at the economic impact of these things. And it's taken the federal government a little while to get on board with this, but they've finally agreed to have an inquiry that will look at exactly this, the economic impact on the entire country, not just the economics of lawyers and law firms, and whether this will streamline the class action industry. We've got a pretty good class action industry. In fact, I think it's a little bit too good. You might remember the litigation explosion about 10, 15 years ago now in personal injury cases. That was caused by the efficiency of really good personal injury lawyers going to extremes.
Chris, I'm just conscious of time. I want to ask you a question that you talked then about Christian Porter, he's the Federal Attorney General. There will be this federal inquiry into contingency fees. What can the federal government do to stop Victoria going down on this path if they're determined to legislate?
Look, if Victoria wants to go down this route, so be it. But what the Commonwealth could do is what the Australian Law Reform Commission recommended in 2018, which is give the federal court exclusive jurisdiction over a number of matters to do with business. Business claims could be made the exclusive province of the federal court. And then all Christian Porter would need to do was make a small amendment to the Federal Court Act saying you can't run contingency fees in the federal court. And at a stroke, that would eliminate any risk that business would face from a boom in class actions in Victoria. Victoria could still run class actions on contingency fees, but the big money claims, which would supercharge class actions in Victoria, that would be over.
That's a very elegant way to neuter the Victorian bill. Thank you for that, Chris Merritt. I'm sure the Attorney General's at home taking notes. Thanks for your time tonight.
Quite okay.